All right, everybody, it's time to go ahead and get started again. Hope you had a good break. I hope you had a good chance to renew old friendships and get to know people a little bit. That's always one of my favorite parts. For the next hour, we're going to be talking about land use law. And we have our two presenters here. One is Gary Crane. Gary Crane is the city attorney for Layton City. He does some other things as side gigs, but that's his main deal. And if you ask me, he is the godfather of city attorneys. And then there's Wade Budge. Wade is from the law firm of Snell and Wilmer. He represents developers, and he is sharp and articulate and smart, and basically he is what I want to be when I grow up. They're going to talk to us about land use law. They're going to hit on a lot of subjects, so we're just going to let them jump in and roll with that.
So it's really a pleasure and an honor to be here, and we've done this repeatedly for a number of years now, and every year this turns out to be probably one of my favorite trainings or conferences to attend, just simply because it's very practical, and everything we do is very practical. I'm the old guy up here. You might find a horse head in your bed if you're as a result of that. Wade's here, he's eye candy, all right? And the rest of us are just old, so except for Jordan, I guess. What we thought we'd do today, what we were asked to do, is just to kind of summarize very quickly some of the issues we deal with. Many of you might be aware of the fact that between legislative sessions, a group gets together called the Land Use Task Force. And the Land Use Task Force is actually a group of attorneys and private developers. In fact, I think they were saying that the PRC, which is the Property Rights Coalition, which is a member of the task force, constitutes about 85% of the residential developers in the state. And then on the other side, you have the cities represented by city attorneys, and you've got some other elected staff as well, planners. Then we have our representatives from the league. I saw Meg here, who does an incredible job of training, but she's actually out in the field a lot and is able to actually identify a lot of the issues that you're raising, those of you that are planners and those of you that are in municipal and county government. So she brings that back to that group, and she brings that richness to it. And the most recent addition is Todd Godfrey, who is working with the league as well on land use issues. And so we appreciate that group. We spend a lot of time going over these issues, and so we were asked to kind of present those things to give you kind of an open door, an open window to be able to look at the stuff that we're looking at right now, and to look at potential legislative progress that we might be making, or legislative suggestions that we will be making. Now, I call them suggestions, but when they get to the legislature and they get hold of it, they're not suggestions anymore. They're mandates is what they are. And they love to point that out, that they're still in charge of the boat and which direction it sails. We do give a little bit of, they being the legislators, we do give a little bit of advice and hopefully direction from time to time. But it's great to work with folks like Jordan and Wade, who are there, and Brent. All of us together have an opportunity of sitting on that esteemed group, sitting with that esteemed group. Let's go ahead and just kind of give you an overview of the items that we were thinking of discussing. And there we go. These are some of the items that we're thinking of discussing. Do you want to go ahead, Wade, and just
thanks, Brent and Gary. Really appreciate you laying the foundation here for today's discussion. I mean, as Gary indicated, we've been working in the Land Use Task Force on a number of issues. These are issues that are the types of topics that come up in numerous planning commissions, city council actions, and also when developers are bringing forward proposals. And so we thought we would bring those forward today, identify, what has been some of the discussion that has been going on these topics. And, there's going to be a time in our presentation where we're going to want to take any questions. I know, and I've worked with probably more than half of you over my career. And so if we recite, a story or a reflection on some prior interaction and we don't get it quite right, feel free to raise your hand and add that detail. But the thought here today would be to go ahead and share some of the things that we've been observing as these topics have been discussed. And then at the end, we want to forecast what we're seeing as possible areas for potential action when you start thinking about what might happen in the next session. So, the first one that was identified is, how do you support land use decisions? And there have been some decisions that have been coming out as of late that have been applying the substantial evidence standard. That is not a new standard. That's a standard that's well developed in the law. But we thought it might make sense to just spend a moment talking about its importance and how it gets applied and about how it should be considered both by the developers whom I represent, when you're trying to go ahead and make sure that your project's well supported so it can withstand any challenge, but also from the city's perspective too, because there's a big drain on the city if you end up having a decision challenged. And so if you have a well-supported decision, you can avoid that. Gary, do you want to?
Yeah, one of the things that that concerns us most, I think, in that group is most of the court decisions that you see coming out now almost blend the legislative standard of review with what is considered the administrative standard of review. So you got a rational basis test, right, for the legislative decisions that we make, and you've got the substantial evidence test for the administrative decisions that you make. And one judge has described the substantial evidence test as being more than a mere scintilla, but less than a preponderance. Now think about that. What is between a scintilla and a preponderance of the evidence? So in other words, it doesn't take as much evidence to make a decision as it does to go to small claims court and prove that you didn't buy that pair of shoes or that they gave you the wrong pair of shoes or something of that nature. So you really don't even have a civil standard, essentially. And so there is a concern there. There has also been a concern with who actually uses those appeal processes and whether or not the same standard ought to apply to everybody that essentially attacks a land use decision or approaches a land use decision. And so we've discussed those issues. I think we probably left behind the idea that we're going to somehow be able to separate the standards of review for different parties that come to the table. But the one thing we can do is we can adequately, hopefully, as municipalities, in order to eliminate attacks on our decisions, put together enough evidence that that the courts will consider that enough to be able to sustain our decisions.
And that's really become apparent as you look at the last several decisions on this topic. If you look at what the courts have been saying, they're looking at standards. They're looking for either, if not findings, at least a clear indication in the record that the various criteria that are identified in the ordinance were evaluated and discussed. And so that's something that I think all of us in the room need to be thinking about. As it's interesting, you go to a planning commission meeting and they're acting as the land use authority, and then they all start making comments and you're just hoping that they touch each element, right? And that's something you need to be thinking about is, are they hitting all of those elements? And, representing an applicant, as I do often, then we're wanting to make sure we've presented that evidence to show that those criteria are in fact met with what was submitted and made part of the record.
Yeah, ideally, it would be nice if we had a written set of findings and conclusions for each of the decisions we make. But realistically, how many of you do findings and conclusions on all of your land use decisions? There aren't very many. I don't do it in Layton. I don't do it in Morgan. So the question is, where do they get the information? Ultimately, where do the courts get the information? Where does Jordan get the information that constitutes the basis for the decision that's being made? And the answer is we still, I asked Jody Burnett one time, are they still The court's still willing to let us sift through a decision and pull out whatever we can when it comes to information the Planning Commission received or the City Council received to be able to come up with that substantial evidence. And the answer is yes. They still allow us to do that. They don't expect an official finding of facts and conclusions, although ideally that is probably the best way to do it. And if you can do it as staff and you can do it as a staff attorney, all the better, because you're going to be that much better prepared when you do go up on appeal.
You know, I think the other element, before we leave this slide, that you need to keep in mind is making sure that the legality component, because there's always two prongs. There's one about whether there's substantial evidence to support the factual conclusions, but then also to make sure that all the legality components are met, so you don't have an illegality claim. So all the legal elements are met. And you know, that's important too, because that's an area that's often identified as a basis for a challenge. So if you're trying to come up with decisions that will withstand that challenge, that's a key component of that.
Just a note on that, your legality requirements come directly from your ordinance. And I always tell my city councils and planning commissions the safest arena for you to be in is in the arena of your ordinance and in the purview of your ordinance. But in addition to that, there's a provision in Title 10.3 that indicates that the opinion of a city attorney is also part of that legal determination. And so either the ordinance or the interpretation given by legal counsel both constitute the establishment of what Wade's talking about, which is the legal basis for whatever decision is being made.
All right, our next slide deals with an issue that came up, has been asked a few times over the last several years. I know this was a hot topic back in 2005 when LUDMA came into its current form, which is a conditional use, and how you go about making sure that you're able to have an approval of a conditional use. The question is can a conditional use application be denied? And up until last year, it was a decision that came down on New Year's Eve. There hadn't been, at least to my knowledge, a decision supporting a denial of a CUP. That was the Springdale case. And it's interesting, if you look at that case, that's a case where it did uphold the denial of a conditional use permit, but it was a plurality decision. It wasn't unanimous, and the dissent, if you read that dissent, is pretty well reasoned. And so I still think it's an open question. I think it's a difficult thing to actually do, is to actually deny a conditional use. And so what we thought we'd do is just run through a couple of points that I think every developer who's maybe pursuing a conditional use permit application, or a city in fashioning its zoning ordinances, needs to keep in mind.
Yeah, if Bruce were here, he'd be doing forward flips, back flips, jumping up and down, stomping on whatever planter he could find to stomp on, because this is his biggest gripe. And in fact, I think this is ultimately the reason he stopped attending our meetings, was because.
Tomorrow, though.
Okay.
He'll be here tomorrow.
That's good.
You only have to see his first name.
Yeah, that's right. That's true. Yeah, Bruce continually indicates that conditional uses are the biggest travesty that he has to deal with out there, and it's simply because they're so discretionary in the types of criteria that we use in order to grant or deny a conditional use. And the old philosophy that you can deny a conditional use is still out there. And the old philosophy that you can apply whatever standard you wish to a conditional use is also out there. And so the consequence of that is that we end up with a lot of conditional uses that are denied even yet today. Every time he looked at Layton's ordinance, he used to get angry because Layton still had those 4 basic criteria that he hates so much, and that is just simply you're trying to eliminate a negative effect. It doesn't adversely affect the zoning ordinance, and I think there's 2 other criteria, but they were so general that you could just about drive a truck through it. And this is the advice I give my council. I would like to get rid of conditional uses because they do cause a lot of trouble, but I realize there's a place for them. Conditional uses, the more you can put in the ordinance, the criteria for any particular conditional use, the better off you're going to be. What I tell the council is, let's take a look at it now that you don't have an application in front of you, and make sure that it doesn't matter what the circumstance is. Think of the worst circumstance you can possibly think of, put this use into that zone, and tell me whether or not it fits. And if you can't figure out a way to make it fit, don't put it in the zone. Conditional uses should not be in the zone. If you can figure out even one circumstance where you couldn't come up with enough mitigating factors to grant that conditional use or to deny it.
Yeah, I mean, what Gary said is so key, because next to referendum, this is the area that I think creates the most contention in a public hearing. Because what you have is you have a decision maker who's acting like a land use authority, but what they're doing is they're wearing an administrative hat. They're not giving policy advice. What they have to do is they have to apply the zoning ordinance. And so even if their preference is that that use not occur in that zone, they have a very heavy duty, and their duty is to just analyze the criteria in the ordinance and look for ways to allow the use and to identify ways that you can mitigate the adverse impacts. And so what you'll have is oftentimes in these scenarios the public coming and they're making comments, and they're acting as though almost every time their comments are about the policy of whether that use is right for the zone, and they're not talking about the specifics of the particular use at that site. And as a result, because the land use authority is just applying the zone as it was already previously passed by the city council, it puts them in this spot where they don't have the tools typically in their toolbox to deny it. And as a result, they're making a room full of people who might be there opposing it really unhappy. And so I like the advice. I've heard it now from Gary and also heard Jody Burnett before then. Don't defer the tough discussions. If you look at your conditional use table and you see in there uses that you fear may not be appropriate in that particular zone, don't put them in that zone. Because otherwise, you're more often than not, if not nearly always, going to have to find a way to try to accommodate that. And the way that my thinking's been formed or shaped by this is really from two ombudsman opinions. One that I think Brent issued both of them, but in one of the opinions, he talked about how important it was that you recognize that a conditional use permit authorizes the use, and you can't just go rely on generalized opposition to avoid it. And that was a case where in Conwood Heights, Greg, where there was an effort to try and make a building be taller as a conditional use. And relying on just generalized comments wasn't going to get the opponents in that case to the position where they could defeat that conditional use permit application. The other one is an opinion, and I cited up there. It's called the Jorgensen one, and that it had to do with a steep slope house in Old Town, Park City, and the initial decision was to deny the application. And it was because the impacts associated with building on the steep slope seemed too severe. And here you can see that there was a serious steep slope involved. And the ombudsman issued a decision in that case indicating that, the landowner had proposed mitigation, and the city hadn't carried its burden to show that it was impossible to propose other mitigation. Because there was mitigation that was offered that the city planning commission did not refute, it went ahead and invalidated the denial. So the point that I got out of Jorgensen is that the mitigation task is kind of a shared task. Both parties, the planning commission and the planning commission and the applicant, both need to be looking at ways to accommodate the use. If you want to give effect to what LUDMA has said, which is that the use shall be approved. I mean, that's the phraseology that's in LUDMA. Now, I do want to recognize that it's really key that if you're saying, look, I need to have a conditional use because there's just a use that we need to have a specific tailoring, and that's the other phrase that we put on that prior slide, then I would really advise that if you're drafting a conditional use permit, or excuse me, a conditional use application, you think about clearly identifying the criteria that need to be weighed and make sure they're really specifically speaking to that particular use.
So some of the best advice I could give a community is, in my opinion, conditional uses are planning WFW. That's what it is. And it just depends on who's in the arena at the time and who's fighting. And oftentimes what I tell my communities is, what I want you to do is go blind for a minute and forget who's actually coming in to apply for this is good advice on any type of application, whether it's a zone change or conditional use, but especially applicable on conditional uses, because that's where you get the crowd. Steve Allred is an attorney that some of you may remember a long time ago, and he loved WFW. And I'd say, so what do you think of all those people down there on the floor immediately around the arena? And he'd say, oh, those guys think it's real. And I don't. I'm up in the stands, right? And seriously, that's zoning by battle, essentially. The old Clearfield case that indicated public clamor was not a good way to make a decision is probably going to be eliminated if you have them close their eyes and forget who they're dealing with and try and make a decision just based on the facts. Bringing them back to reality a lot of times, when I say they, all of us, it's the planners as well as the planning commission, the city councils. Just have them close their eyes and say, look at the decision. Do these facts warrant making this decision, despite the fact that this is somebody that you know that's actually making the application?
I mean, I'd just say, I think it's really easy when you're just looking at the illegality standard, right? And that's, to me, what makes conditional uses sometimes more difficult, is you do got to get really serious about fact-finding and providing evidence, right? And that takes a little bit of extra work. So if you're going to do them, make sure you're willing to provide or make that happen, right?
Let's move on to appeals, if that's okay. And one of the first things that dawned on me when the Ombudsman's office was speaking is that the 6 week, is it 6 weeks? Did you say that it takes to actually come up with an opinion, or is it?
Sometimes 6 months.
6 months.
6 weeks? 6 weeks is great.
Okay.
Has that ever happened?
6 months. Has anybody in here who has actually tried a land use case ever gotten a decision before a year? Anybody on a land use decision? 2 years on a land use decision? Okay, let's go level 1 review, which is the district court. Okay, within a year. How about appellate court decisions? Never within a year. I guess the bottom line is court reviews of land use decisions last forever. I mean, they really do. I wish they went faster. And to Brent's point before, probably the least knowledgeable of anybody in the courtroom when you're trying a land use case is the judge. And I say that respectfully, but Jody Burnett always used to, and I'm going to quote him again, but he always used to say, it takes forever to train the judge, and then you can start to present your case. And that's pretty much it. And then, of course, appellate courts are even faster, right? They catch on a lot faster because they're a lot smarter. No, you got to start all over again when you're in the appeal process. And so appellate review is not a good way to resolve your land use cases, and taking them to district court is not a good way to do that. If you do, though, make sure your record is a good record so that they at least have something to hang on to. And any comments on that?
I mean, I think the only other comment was, when you get a remand, I mean, I see them happen both in terms of, both sides. It's not like it's predominant one way or the other, but that can be a really a problem in the sense that you've already got a process that's taken a year or even 2, as Gary's just indicated. And now with a remand, it comes right back to that same decision maker, and you may have yet another public hearing and another process to go through. So something to think about. And that's really why I think, involving the Ombudsman office to try and get out ahead and avoiding this kind of process is a good thing to think about, because that's a real reality that just stares us all in the face. I don't know, Brent, do you have any thoughts on that?
I agree. I've had situations where the local appeal remanded, and then, so it took even longer to get to the district court. It's a long process, and I'm right now involved in some of that, and it's killing my clients. It's killing them.
Yeah, I just about killed a busload of scouts once for singing the endless song. And some of you may have heard that, but this is the endless song, essentially. Land use appeals, and then remands, and then appeals, and then remands. It's the endless song. Okay, referendum. We have, I don't want anybody to get the idea that there's anybody up here or even down there that does not totally respect a citizen's right to refer things to a vote of the people. The decision, the court has determined that is pretty much sacrosanct, excuse me. A decision of a legislative body that was elected can be appealed by, essentially, or set to a vote by the citizens, and that's not a bad thing. But the problem is that I see is that the majority of times the citizens that are actually taking it up on appeal, and that's what I call it when you actually put it out for vote, are the only ones who care about it. And that became very apparent. Layton experienced a referendum over 107 acres that we were actually going to zone mixed use. And I still remember there was a couple of small farms that people bought produce from. And those farms had a sign up, they're killing us. The city's killing us. They're going to take away your vegetables. And literally, as soon as even the guys in East Layton came down to buy vegetables in West Layton. And so every time they went past that sign, they saw, you're killing us. You're going to eliminate your vegetables next year because there's 107 acres that's developing into apartments, all apartments down here. And it was interesting after we got to talking to our neighbors, the stories that were told at the doors, they went around and got signatures were remarkable. I didn't even know it was the same project when they were talking about it. So that's the thing that's discouraging about referendum. And I'm not even going to, I've spent too much time on this because this is really Wade's bailiwick. This has been the thing that he's still got hair, but it's gray. And he lost a lot of hair over referendum. And we've tried to come up with ways of dealing with it, but go ahead.
Well, I think Gary hit the nail on the head. If you think about what a referendum is, what it is it's an opportunity to send out a bunch of volunteers into your neighborhood to go onto doorsteps and tell half-truths or less than all truths and get people all fueled up on a particular project. And oftentimes a project is a lot more nuanced than that. It requires a deeper understanding. And so, I kind of saw this illustrated. A referendum got filed on one of my projects in my hometown. And I started looking at the referendum sheets who was signing. It was all the people I grew up with were signing these referendum sheets. And I remember when I saw these sheets, I thought, the sheets were presented to me on my birthday. And I thought, I know what I'm doing the rest of my day. I'm going to go talk to my old neighbors and get them to sign removals. But my point is this, that it's easy to go in and persuade someone that, hey, you need to sign this sheet. A lot of times they're not even attacking the project. They'll just go in and say, hey, don't you think we should all be given a voice? Why don't you sign this sheet? Well, what's more American than everyone having a voice? That's very American, right? But those are some of the tactics that are used. And the problem, of course, is that you have a city oftentimes that is expended a tremendous amount of resources in getting the right project approved. There's been a bunch of trading going back and forth. There's been a bunch of negotiation as to what's the right amount of exaction or the right amount of public benefit or community benefit. And all that took maybe 3, 4, 5 more public hearings. That all got boiled down into a decision. And then if you go onto a doorstep, how do you explain all of that content to someone and then expect them to sign a petition or not? The next thing that is kind of problematic is then you'll have the removals. That's a separate campaign. So you got a different set of volunteers out there going and getting removals. And so it's just they're very costly. they can be won, and there have been a number of them that have been won recently. In fact, I was kind of struck by one that happened last November where the developer actually volunteered to say, let's put this on a referendum. And it was because the project was kind of getting mixed reviews within the council, and the council thought, okay, we'll approve, recognizing there's enough of you who don't like it that it will be referred, and that way we'll take the temperature of the community, which was a shocker to me. But at any rate, the point I wanted to make is, 10 years ago, you never saw these. I mean,
So,
rarely.
I have a
Isn't that
question
right?
for you.
Go ahead.
How often do you see them now? Because if your experience is like mine, they're threatened in nearly 100% of the developments my clients do. Doesn't matter what the development is. Doesn't matter if it's high density or low density. Someone files for one in maybe 75% of them.
Yeah.
Maybe they can't get the signatures or whatever, but it's something that comes up every time. And I tell my clients, you need to be prepared for this. This is going to happen.
Yeah, they happen a lot. Where it's more dangerous is when you have neighbors that are well-heeled who are going to finance a campaign, because that's what it really takes. I mean, if it's in a smaller community, maybe you can go out and get the number of signatures. But right now, and we did a presentation on this a couple of years ago, and we might bring it back, but you'll know that if you're a city of the fourth class or greater, you have to have voter participation areas, which means that if you're a signature gatherer trying to oppose a project, you now have to be very organized, because you have to go out within your 45-day period and get the requisite number of active voter signatures in every one of those voter participation areas. The policy behind that is to make sure that if you're going to go through this extraordinary measure of having something put on the ballot that has just been approved by the city council, your elected officials, you got to make sure there's widespread interest in the topic, not just localized around the particular project. And so to answer your question, Brent, yeah, they're threatened a lot. When they do file, when they are filed, it does require a great deal of effort to address them if you're representing the developer. And it takes a real PR campaign. It's not a pure legal thing. What it is it's really morphs into a political and a public relations item. But I don't know, what do you think about?
I'm in complete agreement with you. There's a company called Silver Bullet that actually led some of the campaign against our 107 acres. And I called the guy who had been going from door to door, and I said, who are you going door to door on behalf of? And he goes, I don't know. He says, they just pay me $2,500 and I get all the signatures they need in order to get a referendum. Silver Bullet is actually a firm out of Nevada. He had no clue as to exactly what the issues were, but the mantra at the door was, don't we have a right to vote on the way our city goes, the direction our city takes? And yeah, everybody has a right to vote. This is America. On the other side of that, aren't there things called property rights that we need to do a little protecting of too? But anyway, so it was really frustrating. There is no such thing as not being able to get the number of signatures you need anymore. Call one of these companies, they'll get it for you. If you got about 25 neighbors that are involved, $100 a piece, and they'll get the signatures you need in order to get it done. Just so you know, that's the way the process works, and that's the hard part. So the answer is exactly what Wade said, and that is you got to start really, really early, and you've got to have those neighborhood meetings, and you got to explain to them what's going on so that East Layton knows that the 107 acres is not going to be all apartments, that it's going to be a mixed-use development, that essentially the LDS Church is proposing it, which shocked everybody. But there were many, many wonderful things that they actually wanted, the neighbors actually wanted, but they were told that it was going to be all apartments. So anyway, that's referendum.
I had kind of maybe a question, and I think you kind of already answered it a little bit, but because we get calls all the time from people who are both bringing and defending, right? Are there best practices that you've seen either from the developer side or the city side on how to make a decision maybe more referendum proof that you've seen, smoother on the back end?
We had a project in the cities here in the audience where we did a complete rezone, an upzone, And we sent out our PR folks early, and they're like, "These people hate your guts." I mean, Wade, we've worked with you on a lot of projects. These people hate your guts, and everybody hates your guts. So we hurried and pivoted and went to a base zoning project and just did it all administrative. And the reason we did that, there is a feature in the referendum act, or excuse me, in LUDMA, that allows you, if you're the project proponent, to pull the approval. So you go back to where you were before the matter was referred. And in that case, we invoked that and went ahead as an administrative approval. But the idea was we wanted to lower the temperature in the community on the issue. We didn't want the community to go for 6 months through an election process and a campaign process. That is not obviously going to be the answer for a lot of projects, because a lot of projects require a new zoning district. And as a result, that is a quintessential legislative act. And so you're going to have to deal with that issue in those instances. But I agree with what Gary said. Communicate early and communicate the benefits along with the various elements of development, and just get your message out.
The other thing that you can do is make decisions long before the actual application comes in. So if you've got a master plan and you want to zone according to that master plan, an area for multifamily, it's a lot easier to zone that area multifamily before the first application comes in and everybody wants to tear your throat out. It's easier to bring your zoning in consistent with your master plan and not wait on hard to zone areas. We had a recycling facility in the north part of the city, and before the institution was ever built, we zoned different areas of the city. We did a zoning of the entire north part of the city, and we zoned that area, and one of the uses in there was permitted uses was a recycling facility with very specific requirements of what the recycling facility would require. We never had I don't think we had a single call on that one. So move ahead, think ahead, I think is probably the answer to that.
So the next slide is let's just go back for this. This is the other side of the coin really quickly. This is the initiative side. So this is where citizens go out and they actually initiate a petition. They go out and obtain signatures and they try to put something on the ballot. I've seen it done just a couple of times, never all the way to completion, because it usually gets tripped up somewhere along the way. But this is really kind of this is when we want to become complete in our transformation to California, this is how we show that we are going to be like California, is when we start doing land use by initiative. And I don't mean that in a positive way. No, I mean, this has problems for landowners, because you'll recall in the old days, I'm talking pre-2010, you couldn't do single land use, you couldn't refer single property rezones. Right now, theoretically, although I think there are potential constitutional problems, that's what we indicate in that bottom bullet point on the screen, but theoretically, someone could try to do a rezone of Brent's property, notwithstanding the fact it may create a taking, and those people who have taken the initiative around aren't the ones paying the taking. It would be the city that has the law forced upon it. So that's why I'm saying, if you want to look at the troublesome area, it would be this.
So all of you are probably familiar with HB 98. I'm sure that if I were to divide the room in half of you would be in favor of what happened with 98 and half of you would be strongly opposed to 98. But just some of the consequences, some of the positive things is that the majority of developers out there are trying to sell homes, and so they really are not building homes that are essentially boxes, or they're not converting shipping cartons into homes in most jurisdictions. But one of the spin-offs to 98, if you remember, they precluded us from applying a lot of the design standards that we typically provide in our ordinances regarding brick, regarding siding, cladding, roof pitch, all those things, those fun things that we used to do. You really can't do those anymore unless you do it under a PRUD or unless you do it under a development agreement, a negotiated development agreement. Those are the two ways that you still can do that. One of the spin-offs or problems that we've actually seen is in some jurisdictions, people have come in to rezone a parcel of property to smaller lots. And one of the biggest concern the council had was if you're going to put in smaller lots, these are going to have to look half decent. They can't look like boxes, on a 6,000 square foot lot. And so what has happened in the reverse in a lot of these cases is that they've not been willing to rezone property for smaller lots because they look like boxes, essentially. And so it kind of defeats the very reason that they wanted to get rid of these standards, which was to try and create affordable housing, which, don't get me started. By lowering the cost of a home because you don't require a certain pitch does not lower the price of the home to the end user. The market determines that. And so it has not produced the effect that it was intended to produce. At least I haven't observed it. But anyway, that's aesthetic controls. You can.
But the
maybe
law's
take
only
out
been
some-
on the books for a couple of weeks, so we'll wait to see what it does. But I mean, one of the things though that from the development community, this isn't universal because a lot of developments do go and agree in a development agreement or in a PUD or some of these exclusions that are identified in the bottom bullet. They agree to a higher standard, but I think you did have an example of a few cities imposing requirements that went well and above what the market was going to require, and as a result, that cost was added to the cost of the product. And so that was I think the genesis. I wasn't part of that effort to make this be part of House Bill, is it 98 or 93? Anyway, 98, sorry, 98. But at any rate, that was the policy behind it. And I can see the wisdom for certain product classes because adding more expense and more architectural requirements, while it may look nice, it may not necessarily make that property more attainable.
Have you seen decisions being made to do a development agreement where they wouldn't otherwise do one because of this?
I mean, it went into effect in July. So I think it's something that in a year, I think we'd be in a better position to answer that.
Maybe this is my time to chirp in on something. I have an opportunity of spending a lot of time on the phone with Ross Ford, who's head of the Home Builders Association, and the league tries to solve problems between the home builders and cities. And so if some of you receive calls from us, I'm sorry, I apologize. But at the same time, if I could make one plea, and that is if you're doing something that is absolutely outside of what everybody around you is doing, know this, it's going to come up to the legislature and they're going to change it next year. Things like, gee, let's go ahead and do 100% brick in our community. That'll go up to the legislature next year. Gee, let's
Two-tone paint on the interior.
Let's control the interior paint of this unit. Let's control the number of rooms in the unit. If you're doing something crazy like that, somebody once said to me that if you're on a city council and there is one nut on the city council and you don't know who it is, it's you. If there's one bad community, there's always one bad community, all right? There's one bad community out there, and if you don't know who it is, it's you. It's you. Seriously, that's my plea to you is if they're not doing it over there and they're not doing it, there's a reason they're not doing it over there. And next year it will be all of us not doing it just because that's the way the legislature works.
All right, the next slide, this is a new topic. Well, this is something that passed this last session. You want to talk a little bit about House Bill 82? And then as we talk about forecasting what may come up in the next session in 2022, I think there's probably a continuation of this. But all of you know what accessory dwelling units are. You also now know that internal accessory dwelling units are allowed now in many zoning districts per House Bill 82. Gary, I know you were involved with the ins and outs. What do we all need to know about that?
Okay, don't fight it. just go do it. Leighton made a decision that rather than trying to do the setting aside 25% of the city where it's not allowed, that we go ahead and allow it throughout the city. And these units, we've had all kinds of problems come up, and as those problems are coming up, they're going up to the legislature this year. Do you charge them impact fees when they create one of these, an additional impact fee? Do you count them as an additional unit when you're counting the total number of units within an acre of property? Do you count them as an additional unit? All these will be resolved because the goal of the legislature was to make sure that people could use their homes to house another family or a second living quarter for somebody. And so you got to remember what their goal is, because they're going to get there one way or another. They will get there. An additional possibility, by the way, this is one of my favorite detached ADUs.
This is one Gary maybe designed and maybe built on his own property.
It actually sits in my backyard. My parents have used it for 20 years. We built it in 2020, and it's been one of the greatest things that we ever did, I think. But same utilities that goes through my home, and there's not a separate meter on it, and it's just used as an accessory dwelling unit. It's been used for family, and as long as you live in the front house, it's probably a great idea, and that is coming. I really truly think that'll come. That'll be the next step up at the legislature.
Okay, we're going to go through the next slides really quickly so that we can get to the forecast on what we're thinking might be discussed next session. So next one is a question that's been coming up: what vests at plat approval? You'll know that last session there was a provision put into the code talking about 10-year vesting, and that had both good and bad elements, and that's getting revised. But the basic concept is that when you record your plat, you're entitled to anticipate that those uses that were approved are continue forward. I think that's kind of the summary of that one. That's good. Yeah. Okay, next one is general plan. Gary, you want to kind of talk about how that's been coming up at times?
Yeah. General plans, the infinite and age-old debate is whether a general plan ought to be mandatory or whether it ought to be flexible and dynamic to be able to be changing over time. There's literally the states are split as to whether or not general plans should be mandatory. In the state of Utah, we allow you to make your general plans mandatory. But when they are mandatory, the courts have said you need to stick to whatever your general plan says you need to do. The flexibility is somewhat annoying, I guess, to some individuals because and the argument is this, if the biggest debate that you'll ever have is when you try to approve a multifamily housing unit in your jurisdiction. That's the biggest. I mean, people come out of the woodwork. The only thing that is worse is a group home, right? I mean, that's really it. I can tell some of you have had group homes. But the multifamily housing units, that's what the legislature is aimed at trying to increase the number of. And so, I mean, we've had recommendations on a general plan as to whether or not it ought to, for the sake of affordable housing, be mandatory. In other words, by state law, we mandate that where you have included in your general plan a provision that says this area will be multifamily, let's make it mandatory. And then when it comes time to actually change the zoning, you have to. So there is no debate. There is no you making a zoning decision to zone it multifamily. That was one of the ideas that came about. Another idea that came about to try and get around, once again, the referendum was to make everything administrative, all multifamily decisions administrative, which I don't think the courts would go for anyway, right? We'd probably lose that argument. But
Yeah, they'll do a lot to try and protect that right.
to protect it. And another issue that we've had with the general plans is there's a provision in the state code that says that you essentially have to zone, or your ordinances have to comport with the general plan. And we've had at least one jurisdiction interpret that as meaning If you got a general street plan, you essentially have to amend your general plan before you approve a subdivision that varies from that general street plan. That's really a bad thought process, and it's one that will get the general plan provisions changed up at the legislature. And so general plans are meant to be flexible. They're meant to be dynamic. We want to keep them that way. I think my vote is that's the best way to run a state, is to allow local jurisdictions to change that. General plan consists of two parts, not just the map, but also the wording. And the wording in the general plan ought to be flexible enough to let you change the location of a street if you need to change it off of that little map that you've actually produced and passed by ordinance. So I think that's probably it.
So we're to our final slide, and I think we want to just go through a couple of these really quickly and then take a few questions before we run out of time. But, things to be aware of that are new or important to, should be top of mind. One is there are now new requirements in LUDMA for development agreements. They're mostly procedural, talking about the kind of hearings that need to occur. And it was really in reaction to the Wallingford case, which was out of Moab. Development standards, you want to talk a little bit about that one?
Just before you get off of development agreements, just remember if you got a development agreement that changes the zoning or changes a use in the zone, red flag needs to go back through the zoning process, needs to go to the planning commission, city council, because it's no longer an administrative decision. It all of a sudden you've turned it into a legislative decision. Same thing with settlement agreements, I believe. Wade and I have entered into settlement agreements over property interests where we've actually changed the use on a parcel of property by the agreement. If that's the case, it really does need to go back to the planning commission as a result of this Wallingford decision, and then to the city council, because you've changed that settlement agreement essentially as a legislative process, or legislative decision. Development standards. I think we've discussed that. Oh no, we haven't. Development standards, there is a choir out there of developers that would love to have a single standard throughout the state of Utah for all development that occurs. All engineering standards ought to be the same. All road widths ought to be the same. The thickness of gravel. And I'm being facetious, but
Pavement widths, infrastructure.
right.
Yep.
And once again, what has brought this up is, it's the occasional city that decides they want extra wide roads because they want trails or additional landscaping or whatever else. That's when all of a sudden you get the cry that we got to make sure we standardize these. Let's go up to the legislature. Let's create a body exactly like the building code set of legislators that make decision. Says a set of legislators that make decision on the building code. They would like that type of a process to be in place for they being those that build and those that develop. They'd like that type of process to be in place to design standards that would be the same from St. George all the way up to Tremont. And however, they do recognize that that's not realistic, but they would like some type of uniformity. Am I accurately depicting it? And some method of telling a city or a county when they're over exacting or requiring something that is way more than what you ought to be requiring. That's essentially what they're looking for.
To me, that issue goes back to the advice you gave. If you're doing something different than what everybody else is doing, the law is going to change. It's going to make a story, and the stories is what make the legislators act.
Okay, so that one's still to be seen. We'll see what happens. The next one is administrative decisions by legislative bodies. I know a lot of cities, the council or the commission in a county situation want to be the final word on everything, even if it's administrative, like a plat or some other CUP even. But the problem you have is you have a body that's elected and is used to responding to the electorate, trying to switch gears and applying criteria. And a number of people have seen that as being a problem. And so, there's been talk about potentially limiting that in some way. The next one is speed and decision-making and land use application processing. I mean, I think I've seen that more on like the building permit processing side. I don't know. There are already some features of LUDMA that allow you to kind of try and expedite. So I don't know if that's going to move forward or not, but that has been brought up at times. Vesting, we already touched on that a little bit today. ADUs, we touched on that. And then standing, there are two things going on in standing. Real quick, let me make a plug. Paul Nilsson last month put out a very good memo in a matter about how under LUDMA, you have to meet the criteria in order to have standing to bring a third-party challenge. It's really good if you want to see it. But what it does is it builds on the recent decision from the Utah Supreme Court called McKittrick. And what that basically says in a LUDMA, it wasn't a LUDMA decision, but its provisions can be applied to LUDMA, and it means that those who could challenge an approval of a land use application or land use regulation have to fit the criteria of being either an adjoining landowner or show special damages. And so that's something that's important as you're trying to evaluate who might be the people that would challenge your decisions as a city. The next thing is in the annexation context, it's not as hemmed in. And so there's been talk about maybe trying to make those two similar.
Short-term rentals, good and bad. In some jurisdictions like Tropic and some of the others, little towns in Utah, they're starting to feel a pinch of short-term rentals coming in. They're being bought by people who renovate the whole thing, an older home, and now their kids can't buy homes because that short-term rental is worth 5 times what it was when they first bought it. So there's talk about removing that prohibition on cities looking at the advertisements for short-term rentals as a method of enforcement. So you would allow short-term rentals, but you'd be able to at least have a tool for going out and finding those that aren't registered and aren't properly business licensed. That's it.
Time for a couple of questions.
Does that apply to referendums like neighbors? It would have to be a neighboring party in order to.
No, unfortunately, no. The reasoning of the Supreme Court is this, that if a statute gives the city the right to go ahead and act in a certain way, in this case, create zoning ordinances, then the legislature can, at the same time, describe who can bring challenges under that grant of authority to a city. But because the right of a referendum comes from the Constitution, they're putting that in a completely different lane. Does that seem right, guys? Yeah.
One other question. So on accessory dwellings, is there any restriction about limiting those to family members? So if you have an accessory building, I know that some cities have tried to say, well, it's okay as long as you only allow family to be in the accessory building.
Yeah, that's gone. Now, the owner of the building has to occupy it. That's all. It can be family. It can be as long as the owner occupies it. And the interesting thing is, I've never seen a preemption yet where they've actually preempted the CC&Rs. Legislature preempted the CC&Rs. So you can't even create a CC&R that says it has to be family. So. Yes. Yeah. It's effective today. So anything that, the one thing that you do have going for you is that if the thing wasn't properly approved, the residential or dwelling unit, secondary dwelling unit was not approved, you can make sure that they are properly approved and licensed. And so when you say, is it retroactive, somebody comes in and says, I've got one of these in my basement. First of all, they've wiped out all the building requirements as well. So you really don't have to have a separate unit down there with separate air conditioning, everything else. So it's going to be pretty easy for them to establish it, but at least you'll know it's there. Over here? Okay. There you go.
Is there a way, like in the city code or somewhere, to tell if a general plan is mandatory?
Yes, because in order for it to be mandatory in the state of Utah, you have to say in the ordinance, it is mandatory. That you have to actually say this general plan is mandatory. The zoning must be approved according to this general plan.
Please don't go.
Yeah, please. I'm not
It'll be
recommending
unique
it.
if you do it.
Yeah. And you'll regret the day that you did it.
Okay. That's it. That's our time. Thanks, everyone.